May it please the Court, I'm McMillan Powers, and I represent Vincent Rowe in his appeal of his conviction for grand larceny and grand larceny within the Texas cell. Factually, this case is a little bit unique, but it's more unique procedurally. You've just had a procedural case involving whether or not 518 and now 525 come into play on a contemporaneous objection, and we have a sort of similar issue here. The issue before this Court is whether or not the Court of Appeals erred in holding that the defendant had procedurally defaulted by not preserving his objection to an improper argument by the Commonwealth's attorney at the closing argument and subsequently moving in a timely manner for a mistrial. Now, for review purposes, obviously, if it's a motion for a mistrial, it's an abuse of discretion. However, as the Court's already just now explained, if it impacts a constitutional right, then we have a different standard of review. It's a de novo review, and then you have to look to whether or not there is a fundamental right being impacted negatively, and if it is, can you say beyond reasonable doubt that it did not impact the verdict? Well, that's where we are today, and we submit that the comments made by Mr. Knowles, the Commonwealth's attorney, did adversely affect the rights of the defendant. It effectively shifts the burden of proof from the Commonwealth to the defendant when the attorney, the Commonwealth says, at this stage, you've heard no evidence from the defense. Well, the Commonwealth's response to all of that has been, throughout the entire event, that what Mr. Knowles was really talking about was a comment on the inference instructions that if you are in a recent possession of stolen goods, there's an inference, or you can make an inference, you don't have to, that you're also guilty of statutory burglary. Well, that's not what Mr. Knowles was arguing, because if you'll look in the record, he begins his argument on inference at about page 105.
So before you get into your argument, let's talk about whether the trial court had a chance to get it right in this case. Why do you believe that defendant's failure to make this objection to the trial judge in a timely manner should be excused in this case?
Well, we believe that he did make a timely objection. And if you look at the record on page 108 in the appendix, at page 108, Mr. Knowles makes his statement that we've heard no evidence.
Right. So what was the defense objection?
Within seconds after that, defense counsel stands up and says, Your Honor, before I make an argument, I have a motion I want to make outside the presence of the jury. At which point the court immediately says, before counsel can say anything or even articulate the objection, he says, we'll deal with that when the jury retires. He's already made a decision.
Now, wait a second. Do you think 801-384 saves you there?
I think that 801-384A does, because...
Tell me why.
He does not have an opportunity to express what it is that the objection really is.
Well, unlike the last case, he's present. He's in the courtroom. He could have said, I understand, Judge, but I really need to discuss this at sidebar. But we tell trial attorneys they can't be shrinking violence. You've got to let the judge know what your argument is.
And the cited cases say time and again the responsibility as trial counsels to make the objections even when it's uncomfortable, even when you risk the wrath of the bench. I understand that as a trial attorney, and I think everyone who tries cases knows there's a certain amount of delicacy as to how far do you push it with the judge and how far do you retreat.
But sometimes you got to do it.
At this point, in this courtroom, at this time, the demeanor and everything was, don't say another word. I'm going to deal with it. It's foreclosed.
How do you know that from the record?
I don't know that from the record, except that as soon as the statement is made, I want to make a motion. Counsel, I'll deal with it later when the jury retires. And at that point, it's over. Immediately after the jury retires, it is put on the record. But it's not an argument. It's just a preservation of the record. He's stating what his objection is and why that objection is a good objection.
Mr. Powers, assuming that what happened there was sufficient to put the court on notice that you had problems, not you, but whoever tried the case. I think the real problem in this case is that when there's an objection, and it's an objection that is sustained, that you have three possible situations. One's mistrial, one's a curative instruction, and one would be an instruction that is more generic to ignore what just happened. And a lot of lawyers don't want any more focus on what just happened, and they decide they're not going to do that either. My problem with the case is that the motion for a mistrial apparently did not occur until after the verdict.
That is not correct.
When did that happen?
That is not correct. If you will look in the record, the motion for mistrial is actually made, and this is an error that has just continued to crop up throughout the appellate process. But if you look at the record on page 100, and I believe it's 120 in the appendix, Mr. Andrews is now. Unfortunately for us, the court reporter did not give times like they did in the case you just heard argued in Maxwell. There's no times here. But the jury now retires on page 119 of the appendix. And on 120, Mr. Andrews is making his argument, and then at this point he says he moves for the mistrial, and I have a motion for a mistrial based on that at line 13. This is while the jury is out. They have just been instructed. The first opportunity that Mr. Andrews has to make the objection and to raise the issue and to ask for the mistrial is on page 120 at line 13. Jury's out. At this point, if we're looking from the recent scenario in Maxwell, at this point, something prejudicial has happened, in our opinion. An instruction. As you say, we could do a mistrial, and then we're going to have the review and do all that. Was it an abuse of discretion, or was it constitutional to the extent that, now you got to go beyond all of that and talk about prejudicial, and does the Commonwealth have to meet that burden? Or do you get a curative instruction, or you just get a cautionary comment? None of that happened.
But just, counsel, to back up just a step, I see a fundamental difference between defense attorney not being in the courtroom and defense attorney being in the courtroom and just not saying anything because he's afraid he's going to hurt the judge's feelings.
I didn't try the case. I don't know. All I know is at the first opportunity in the record that Mr. Andrews has, he states his objection and he asks for the mistrial. That's his first opportunity. When he first opens his mouth to say, I have a motion outside the presence of the jury. If that doesn't tell the court, the judge is sitting on the bench, he knows he wants to make something known to me that if said in open court is going to impact the jury. I better listen to this. So I have a couple of things I can do as the bench, and this is what the bench always does.
But here's the language of 384. If a party has no opportunity to object to a ruling or order at the time it is made, the absence of an objection shall not thereafter prejudice him. How does this case fit within that?
I think that the way this happens is he made the objection.
You think soon enough is
I think he made it soon enough there at page 108. He makes the objection, but before he can articulate the basis of that objection, he is stopped. And then at his first opportunity on page 120, he makes the objection. He lays it out very succinctly.
Let's go one step further. When he first made the objection, how could the court have gotten it right? He was supposed to, in his own mind, just sort of guess what the objection was? No, at that point, on page 109, he could have let him finish stating the basis for his motion. He says, I have a motion I want to make outside the presence of the jury. Well, it's not going to be a motion to strike because we're past evidence coming in. What is it going to be a motion for? Must be something that's going to be relatively prejudicial because he wants to make it outside the presence of the jury.
But, counsel, Mr. Andrews' response at that point was very well.
Very well. And my response to that is, and lame as it may be, I'm a believer that courtesy and respect for the bench does not voluntarily surrender constitutional rights. Mr. Andrews was acknowledging the right of the bench to run his trial the way he wants to and to run his courtroom the way he wants to, and we all do that. At that point, he acknowledges, fine, you don't want to hear this objection now, you don't want to hear my motion, I'll put it on the record first thing, and he does. He plays by the rules of the court, and because he does that, he has not surrendered any constitutional rights that his client has. And that's the issue here. How soon, how vigorous, all of those issues. The vigor with which we object as trial attorneys is always tempered by the reaction we're going to get and the blowback we're going to get from the jury. When we start having a fight with the bench and the jury senses that, every one of us has tried cases, and we know that tension, and we know that's a fine line to walk. Now, we can sit back now and debate whether or not Mr. Andrews made the right decision and did it the right way and all that. That's not the issue. The issue is, did he do it timely? Did he do it sufficiently? And I believe that the record supports he did both. Now, the other issues that are involved all revolve around how we got here. I don't think those are really at issue at this point. We're here because you asked us to be here. We begged for permission to be here on a default and to have a delayed appeal. That's why we're here, and we believe that the issues are well preserved. They're here. They're significant issues, and I believe that this court can do a couple of things. Obviously, you can just make a decision, figure it out right now, say it goes back for a new trial, reverse remand, and go back, skip the Court of Appeals. Or you can send it back to the Court of Appeals and let them figure it out. Or you can send it back to the Court of Appeals with an order saying you remand it and give it back to the trial court for a trial limited to the issue here of, whatever. Do you try the whole thing all over again? Well, how are you going to segregate it? Because he gets acquitted of one of the offenses, and so that really impacts the whole idea of the inference argument. If the inference argument is there, well, the inference was he'd been guilty of statutory burglary, but they found he wasn't. That's because other evidence wasn't sufficient on statutory burglary. It has nothing to do with inferences. That's the way we see that. What we would like to do is we would like for this court to remand this case to the trial court for a new trial on the issues of grand larceny and grand larceny with intent to sell. I'm going to reserve 3 minutes if I may.
All right, thank you.
May it please the Court, I'm Virginia Tyson on behalf of the Commonwealth, and I have 3 arguments to make. The first one is that this appeal should be dismissed as improvidently granted because the appellant was not entitled to a delayed appeal where only one of several assignments of error was dismissed on procedural grounds. Secondly, that the Court of Appeals did not err in applying 5A18 under the specific facts and circumstances of this case. Thirdly, that even if this Court were to find that the Court of Appeals erred in applying Rule 5A18 and the Court addresses the merits, as this Court did in Angel v. Commonwealth, that the judgment should be affirmed. I realize, as my opponent has said, that we're here now, that this Court granted a delayed appeal. But my argument on this particular issue is that the statute which gives this Court its authority to give a delayed appeal does not provide for one in this circumstance. That statute, which is 19.2.321.2, provides that this Court may grant a delayed appeal when an appeal has never been initiated, when an appeal has been dismissed because of procedural form or timeliness error, or an appeal has been denied, the conviction affirmed because of a late filed transcript. It's not an issue. The statute does not provide for a delayed appeal on an issue. It provides for a delayed appeal on an appeal. And that's not what we had in this case. And this Court gets its authority from the statute, and the statute does not provide for it. And obviously, I have to make the argument that it is jurisdictional because this Court has to get its jurisdiction from the statute. I also would note that I have seen...
Your argument that the Court should have granted all of them or none of them, that's you can't just piecemeal grant an issue?
No. Actually, my argument is that it could not be done in this case because several assignments of error were refused. 2 or 3. I'm confused as whether it's 2 or 3. One assignment of error was dismissed. And so this does not fit in, no matter how many issues this Court were to grant a delayed appeal on, it doesn't fit into the statute. It does not fit into the parameters of the delayed appeal statute because it wasn't totally dismissed. It wasn't affirmed because of a late transcript. There was simply one assignment of error. And of course, anecdotally in habeas corpus, this comes up from time to time. In this situation, we're dealing with Strickland prejudice rather than a delayed appeal or an automatic related appeal. And the statute it does not provide for a delayed appeal in this circumstance. And thus, our initial argument is that this appeal was improvidently granted and it should be dismissed.
Ms. Eisen, let me ask you this. When this case first came to us and we were looking at that and realized that we had at least one assignment of error that could not be reached, which is this one, if instead of parsing it out at that point, we had just said, okay, we're dismissing this appeal, and we had just entered an order that dismissed everything and then granted the delayed appeal, would you make the same argument?
If the order simply said this case is dismissed on procedural grounds, if the order said this appeal is dismissed on procedural grounds, it would then fit into the statute. And because it wouldn't be an accurate description, though, because the rest of the assignments of error were not.
We might be wrong about part of it, but the order would fit the statute.
The order would fit the statute, but it wouldn't fit the facts of the case because
I understand that, yeah.
The other assignments of error were refused. And so that is our initial argument, is that this case should be dismissed because there should not have been a delayed appeal granted. With regard to the waiver, it is our position that the Court of Appeals correctly apply Rule 5A.18. Certainly this Court's decision in Schmidt, which is 262, which is after Burns, says that a motion for mistrial is untimely when it's made after the jury has retired from the courtroom, which is what happened in this case. And yes, the trial court did say exactly what Mr. Powers said that the court said. And it's on page 108 is where we start. It's very critical. Although, if I might, just a moment, let me back up just a minute. Because the whole issue, the claim of error, is the prosecutor's argument that the defense had not presented evidence. And really, that issue had been going on all during the discussion of the instructions because it deals with inference. And when I get to the merits argument, I want to talk about the inference. But page 108 is really on the appendix where we start with this. And the prosecutor says those words that counsel alleges were improper. He says, if you feel it's justified in this case, meaning the inference, then to find him guilty. There's no objection during the prosecutor's argument at all. The prosecutor finishes up his argument by saying, ladies and gentlemen, I request that you find him guilty. And then the court turns to the defense counsel who says, actually, before I make my argument, there is a motion I would like to make outside the presence of the jury. And the court says, we'll deal with it when the jury goes to retire. It is our position that defense counsel needed to do more than that. Counsel notes in his brief there was no sidebar conference, and yet there was a requirement to ask for that. I know we cited to the Knight case in our brief, because certainly it's not our argument that one must be discourteous, but there are times where an additional argument needs to be made, and this is one of those instances.
So, Ms. Tyson, you know, part of this has to do with local customs and understanding judges. I mean, I don't know in this case what this judge does, but there are judges for whom that is always the answer. You don't make an objection and state it until after both sides have finished their argument. I happen to think that's not very good practice, but there are judges for whom that's always the answer. You've been out there in the courtrooms of the Commonwealth. So what happens when a lawyer who practices in the community, knows exactly this is what Judge so-and-so does, I'm standing up because I know I have to alert him, but I know this judge is going to say, wait, no, I'm not going to interrupt this process. You wait until you finish your argument, and I'll hear you.
I understand that, Your Honor, but I also know that a lot of times the blame can be placed on the appellate courts, that the appellate court requires that I do this, and I must do this to preserve this issue for appeal. And I'm certainly not suggesting that that's going to be the answer every time. But even though things may be difficult in the trial court, it has an effect then on what happens to the case after it leaves the trial court and becomes up to
we may very well be at fault for all this. I mean, I'd be willing to suggest that we ought to examine what we say in our cases. Maybe this is one where we could do it. That's why I'm so interested in it. Does a lawyer have to push and say, Your Honor, I would like to explain now? The record judge says, no, I told you. No, it's right here on the record. No, I told you. You're going to wait. But, Judge, I want a sidebar now. I'm sorry, counsel. I've already told you. I've ruled on this matter. Is that how far you have to go?
I know you're right. Certainly I'm not suggesting that one needs to be contemptuous in order to satisfy this rule. I'm saying specifically in this case, there wasn't enough.
What should there have been that wasn't done?
In this particular case, the counsel needed to ask for that sidebar, to even say that I have an objection. Notice there's just a request for a motion. To even say I have an objection to what the prosecutor has stated in his argument, and therefore I need to make this motion.
Okay, counsel. Let's just stop right there. In the case of this trial, the only thing that has happened since the jury came back post-instructions is closing argument. So when the judge says, when the attorney says, I have a motion, can the judge think that there's anything other than an objection to something that was just said during the closing argument?
Well, Your Honor, probably not. Probably the trial judge had a pretty good idea. But how can we be certain?
What does 8.01384 require other than that the attorney give the judge a pretty good idea of what it is he wants to say?
Well, I think there's a requirement for a specific objection, and I think that's what 5A18 and 5:25 require, is a specific objection, and we don't have that.
So he had to use the magic word, I object. Is that it?
I think he needed to say that there was an objection to the argument, that request for the sidebar to make the motion for mistrial was necessary.
Tell me, what other than an objection would an attorney possibly want a sidebar about immediately after the Commonwealth has finished its closing argument?
He would want to make an objection.
Indeed. Is there anything other than an objection that he could possibly, that you can think of?
No, I can't, and especially because he's asking to make this motion outside the presence of the jury.
So then it doesn't matter whether he used the magic word, I object or not.
I think that it is important because that's what the rules of this court require and the case law of this court. The cases, as we cited, for years and years and years have said that if one wants to preserve an objection to an argument of a prosecutor, you must make the objection and then either ask for a curative instruction or a mistrial before the jury retires.
If I were to say, if I were to be the attorney, if the attorney were to say, Your Honor, I have a concern about what was just said. May I have a sidebar? Would that have been sufficient?
I think that there needs to be an objection.
There has to be the magic word.
I think that an objection, there must be an objection under 518.
Judge, what was just said by the Commonwealth's attorney is legally improper. May I have a sidebar?
I think that's sufficient. Because you have made your objection. You are pointing out to the judge that something objectionable has occurred.
But you haven't used the word objection. Again, what could he possibly have wanted a sidebar? What could the judge have interpreted his question to be other than an objection?
I think that there is a responsibility on counsel to make the objection, to make the specific objection. And I want to point to Angel because...
But he's saying, I want to make the objection, but I've got to do it outside the presence of the jury. And you're saying, well, the only way he can do it is to make it within the presence of the jury.
No, I think that he needs to ask the court. He needs to give the court enough of specifics of his objection, of why he needs to have that sidebar outside the presence of the jury.
But it's circular. He's got to be outside the presence of the jury in order to give the specifics.
Yes.
And the judge won't let him do that.
Well, the judge says we'll deal with it later. That's the only thing the judge said. And then we moved on. And then he made his closing argument where he addressed the inference, which is a major factor that distinguishes this case from Angel. I wanted to talk about that case because I do think that's a very important case where this court said the Court of Appeals erred in applying 5A18 because nothing happened between the objection and the motion for mistrial. And the jury in Angel, although they left the courtroom, were not deliberating. They were merely deciding when they were going to deliberate. So I want to make that point because obviously this is a recent case from this court where the court found the Court of Appeals erred in applying 5A18 in a similar, although distinguishable, set of circumstances. The other thing that I would like to say with regard to Angel is this. Under ordinary circumstances, I think that we would argue that if this court were to find that the Court of Appeals erred in applying the procedural default rule, that this case would go to the Court of Appeals and have them address the merits. But what I noticed in the Angel case is that this court said, Court of Appeals erred in applying 5A18, but we find that there was no error. And thus, we addressed in our brief, as opposing counsel did, whether there was an error. And there was no error in the court denying the mistrial in this case. And I want to be able to make that point to the court that under Dobson, this court's opinion in Dobson, there was nothing wrong with the instruction on the inference for the larceny. As we know, the jury understood it was permissive because they acquitted the defendant of the burglary. There was no error in denying the mistrial because there was no error in what the prosecutor had argued. And thus, this is my number 3 argument, should this court find that the Court of Appeals erred in applying 5A18, we would urge this court to do as it did in Angel and say, but there was no error here. So, in summary, we would urge the court to find that it was improperly granted, that the Court of Appeals properly applied 5A18, but in the event the court finds that the Court of Appeals erred, to rule that there was not an error and affirm the judgment as it came from the trial court.
I have one additional question. It goes back to Justice Mims' question. You seem to be arguing that the defendant needed to say, I have an objection as opposed to having a motion. But once the trial court said, we'll do it when the jury retires, wasn't at least what the defendant needed to say then, this can't wait?
Yes. Yes. And as I said, with regard, if I may finish my answer, with regard to, we've got requirements of the appellate court, or I need to preserve this should there be an appeal. I think those are helpful terms in saying why we need to do it right now. Okay. We need to do it right now.
Or at least something like, Your Honor, this motion needs to be made before the jury retires. Something like that.
Yes, sir. Absolutely.
Okay, thank you.
Thank you.
Just a few comments here. Going to the issue that this court has just addressed and counsel for the Attorney General's office has talked about, what the defense attorney must say, the words.
Before you go there, why don't you address her argument about that we shouldn't even be hearing this case?
Okay. Well, if you want to, that's fine. I will be more than glad to talk about why we should be here. We should be here because this is a perfect case for 525. This is the case where an error was made in the trial court. That's our firm belief. There's a substantive constitutional error.
No, but this came through the delayed appeal process.
Then it goes to the Court of Appeals, and then the appeal to this court doesn't get perfected correctly. It doesn't address the failure to address the 5A18 problem. And this court says that's dismissed.
We only dismissed one assignment.
And just dismissed one. The other issues were all denied. That one was dismissed. And then, for whatever reason, the appeal on that doesn't get done properly. I'm not sure exactly how that happened. But a delayed appeal is then requested. In fact, there was some idea of a motion for a rehearing, and that didn't go. But on the delayed appeal, it's granted, and the grant of the delayed appeal, and it's right there in the appendix, I think on page 246 or 248, the grant says specifically issue 3. And it is narrowing it to that. It is an order of this court, and if you were to say that we can't be here procedurally, then you would say, then you can never just take 1 or 2 issues on appeal. When you come to the written,
her argument is that the use of the word appeal in the delayed appeal statute means that the entire appeal has to be dismissed for this procedural problem, and not just an issue within the appeal. This entire appeal was not dismissed.
No, the entire appeal was not dismissed. Two of the issues were dismissed. This third issue was defaulted procedurally.
It was dismissed. The rest of the appeal was refused.
Right, and they were all just denied and refused, and those issues just went away. This one then was dismissed because it was not properly preserved. It was defaulted. What I'm saying is, if you're going to say that you can never use that tool, then from just an economic standpoint, just a judicial economy standpoint, you would never be able to look at one issue that might be significant. Then you have to relitigate in the appellate court and in this court all the issues, and that may not be something that this court wants to do. I would suggest it's not something this court wants to do, to litigate again on an appellate basis every issue that's already been litigated, when the only one that's important is the one you really want to listen to. And that's why I think we should be here.
All right, thank you.
My time is up.
Thank you.
All right. Thank you very much.